and read to their accused. They were asked and had no objection to any member, and that was in pursuance to the regulations. In that regard, we would say that an issue of impartiality does not arise in these proceedings because the accused have not objected to any member. On this same provision, Regulation 49 of the UPDF Rules of Procedure Regulations requires the opinion of each member. As a way of handing down verdicts. So a challenge to the impartiality, of course, should go to the opinion holder, and since names were disclosed, that would be the approach. And this is also the approach in civil courts. I'm glad Honorable Martha Karua told us she has been a judicial officer, and those are the principles of civil court, where you request the judicial officer to excuse themselves. Regarding issue number 1, it deals with whether the offense under offenses relating to security, section 128, F of the UPDF Act defines the offense. Mr. Kalibara says that it does not define the offense, together with Mr. Panga, and their view is that because it says the person who omits or does an act. When you cross-reference with other laws, an offense can be constituted by an omission, it can also be constituted by an act. Even in the penal code, an unlawful act or an unlawful omission can constitute an offense. There is also a requirement in the offense that the intent must be to prejudice the security of the defense forces. Those are matters once alleged that are supposed to be the subject of evidence, and the burden is on the state. But at the moment, this issue is premature. It is determined with evidence, and this court can decide that matter. There is also an issue regarding whether the trial of civilians in general court martial is consistent with decisions of civil courts in earlier cases. And one of the cases cited is the case of Honorable Michael Kalviduka versus the Attorney General. Most other cases cited, including retired Captain Amon Bialgala and Semunju Abduminana, we are referring to that decision of the Constitutional Court. But the decision is pending before the Supreme Court. And the orders and declarations made in that decision were stayed. So it would not be an authority that determines the position. We would rely on area authorities. The area authorities included the case of Hadija Namugeba versus Attorney General, Civil Appeal number 424, where they said the provision of section 119, which is now 117 of the UPDF Act, is proper. And charges can be maintained under that provision. There's also an issue number 7, whether the General Court Martial has jurisdiction to deal with cases under the Firearms Act. The UPDF Act defines a service offense to include offenses under the Act and those under any other act for the time being in force committed by a person who is subject to military law. And the Supreme Court has pronounced on this in Attorney General versus Uganda Society. At page 10, and in that case, with a unanimous decision of the Supreme Court arising from the constitutional appeal, they only required that for an offense under an act other than the UPDF Act to be within the jurisdiction of the General Court Martial, it must have been committed by a person subject to military law. And what they required was to allege and show that the accused persons committed either of the two offenses where they were subject to military law. That is the link they required. And the applicants have not shown that that link is not in the charge sheet. And it is the burden of them to show that there is no link. It is not a link that these people were subject to military law. We also wish to point out that there are procedural safeguards for the trial of persons before the court, including presumption of innocence, burden of proof, and these are matters for a trial court. These are not matters that require constitutional interpretation. That I hand over to my colleagues to continue.
Lord Chairman, I would like to back up the submission of my Captain Campos. I'll begin by quoting Article 152, Clause 4 of the Constitution. It says that the Supreme Court will, while treating its own previous decisions as normally binding, depart from a previous decision when it appears to it right to do so, and all other courts shall be bound to follow the decisions of the Supreme Court on questions of law. The Supreme Court has severally decided that these courts have jurisdiction to try the accused persons. And my colleagues on the other side repeatedly citing the decisions of the Constitutional Court would be in contravention of that specific article. And then I will reply to the other general issues, specifically on Regulation 63, Regulation 2, and Regulation 69. Lord Chairman, the General Court Martial operates under the framework of the EPDF Act, which ensures its independence. The Act provides a clear separation between the administrative functions of the High Command and the judicial functions of the General Court Martial. I refer you to Section 14 of the EPDF Act, Cap 330, and Section 195, so it establishes the General Court Martial. While the High Command may oversee the General Military Administration, it does not interfere with the judicial making process of the General Court Martial. Members of this court, including its chairman, are carefully selected and sworn to administer justice without fear or prejudice. Whether this is under Regulation 14 of the Uganda People's Defense Forces regulations. They are guided by the principles of fairness and impartiality enshrined in the Constitution, Article 28, and the EPDF Act. The presence of the legal officers and adherence to established legal procedures further guarantees impartiality of the proceedings. This court has autonomy in its decision-making process. It conducts trials based on evidence, law, and legal principles, not directives from the High Command. The decisions rendered, furthermore, the decisions rendered are subject to appeal and review by superior courts. By superior courts, I mean the Court Martial Appeal Court. This is provided under Section 225 of the EPDF Act. The relationship between the GCM and the High Command is administrative, not judicial. The High Command's involvement ensures logistical and institutional support for the court martial, but does not extend to influencing judicial outcomes. Now, concerning Regulation 63, Regulation 2, it is very clear the role of the judge advocate is to advise the court on matters law. If the court disagrees with the decision, they shall record in the proceedings in its reasons. It does not mean that they are entirely binding, as one of the colleagues on the other side alluded to. My Lord, I give way to my other colleague to submit. Let you know.
Chairman, board members, straight over to the question framed by my colleagues, especially question 6 on the arrest issue and 5 of former 2, which is persons that is unretired, that is arrested and at Besigye. Chairman,
And when I brought members, the ruling that was rendered by this court today morning settled that. And in that ruling, the court clearly pronounced itself as far as the arrangement that is between the two countries, that is Kenya and Uganda. And my chairman, that arrangement is backed by the law. It's backed by the East African Community Treaty, of which Uganda is a party. Not only being a party, but it also domesticated that treaty. And the same thing, domestication, was done by our neighbors, that is Kenya, also domesticated that treaty. So, my chairman, under that treaty, specifically under Article 124, that addresses the protocol of peace, on peace and security. And the article outlines the commitment of partner states to cooperate in issues related to peace and security. And my chairman to put into motion, or to put into practice that cooperation. That's when we see the coming up of that memorandum of understanding for the two states to cooperate on matters relating to security and cross-border crimes. Therefore, we also refer to this court the authority that my brother and senior colleague, Council Pago, alluded to, the one of Amar, Awad, Umar, and 10 others. And my Lord Chairman, that's a very good authority, because it clearly highlights the role of states that are parties to the East African Community Treaty. And if I may, on page 70, page 71 of that judgment, my chairman, under paragraph 30, if I may read verbatim, states that we also observe that East African Community Treaty was domesticated in Kenya, Tanzania, and Uganda. Uganda Parliament enacted the East African Community Treaty Act of 2002 by virtue of statutory instrument number 29 of 2005. The East African Community Act amendment instrument 2005. It came into force but the argument I'm making is that there indeed exists an arrangement between the two states, the two partner states, that is Kenya and Uganda. This one was confirmed by authority that was clearly and well cited by my senior colleague, though with broad interpretation from the side. But be as it may, my Lord Chairman and honorable board members, we submit that indeed the laws were followed. In other words, in the absence of the extradition treaty between Uganda and Kenya, this law applied squarely in both countries. My Chairman also, and that one would not really need a reference to that bit, otherwise it would be a waste of God's time. But Chairman, on the other issue, which issue 2, and my senior colleague earlier looked at it and submitted it, but maybe to add something that is important. We really rate all the authorities that we are provided to us by our colleagues, and two things are cut across in all those authorities. My colleague talked about it. There is a recent ruling. This one you may not need to refer to the Constitutional Court. And that ruling was very clear, staying the execution of the Besigye case findings. It is as plain as that. You don't need to refer to court that interpret this or try civilians. It will be absurd, very absurd. And our chairman, further on that, we also confirmed that indeed the decision, the authority that was cited by Steel Council Lukwago, one of Abdul Semuju aka Nana, the issues that had been raised in Besigye case were the same issues that were raised in Nana, and he can testify that unit. So, my chairman, it would be the feat of justice, and not only that, but also wasting court study. Now, also apply to stay the execution of Menara. Though there has been an appeal, we are aware, and the Council is also aware that there has been an appeal against the decision of the Constitutional Court. And, we are yet to know the hearing dates. But, my chairman, we submit that we base the trial of civilians in this court on the decision for the ruling, staying execution, the decision of Besigye. And therefore, in this matter, Nana cannot really suffice.
As you're watching Extreme Media Yoki.
As I conclude, my chairman, and board members, I would also like to add something on the question of impartiality that my colleague talked about. Like whether the General Court Martial can be impartial on adjudicating matters before it, and the reference was made to 28.1. Madam Chairman, my colleague addressed that, but to add something, under section 207 of the APDF Act, where rules of procedure and evidence that apply to civil courts can as well be applied to general court martial. That is in the law.
Subscribe.
And Chairman, that goes back
Like
to
the video and share the link.
the supremacy of the Constitution. Now, under that Constitution, it provides
Watching
clearly
Extreme Media UK.
two things: the impartiality of courts. So it's out of that law that is now 207, it applies to general court martial. So what my colleague said, and that article under 128(1) of the Constitution and 2. So impartiality really it is there. This code is impartial. And Madam Chairman, lastly, I wish to also add on what my colleague said, and that is on the procedure, on how you refer a question for interpretation of the Constitution. Madam Chairman, that one was settled by a constitutional court in Ismail Selko against Kampala City Council. And Justice Wampunzi then was very clear, extremely clear. He stated that the petition can just that with the necessary modification reference must show on the face of it that the interpretation of a provision of the Constitution is required. But Chairman, what we saw today and the framing of questions was an appeal in disguise. An appeal in disguise. The questions, the way they are framed, we would actually say that the counsel for the accused persons under the Court Martial Appeal Court rules to appeal against the ruling that was rendered today morning. Other than casting a net, let us see what comes out of the lake. The court does not operate like that, Madam Chairman, and I pray that you should not allow that to happen in this court. Madam Chairman, that was also emphasized recently by the Constitutional Court reference number 31 of 2010. That is Uganda against Francis Atugonza. And the court stated that constitutional reference by the court that is determining the cause or a party to the proceedings will request the court, and this goes back to what my colleague, Senior Counsel Kalibara stated, that the court, so the hands of the court are tied, quite absurd. They are not. That's why you're here. No, Chairman, that statement itself, it simply puts a constitutional court into a position of applicability of the law, of the rules, which I disagree with my colleague. The Constitutional Court can apply the law in other instances, but as far as constitutional reference is concerned, it's basically interpretation, not applicability. Not applicability. Applicability is with the authority of court. Now, whether the court, I'm not saying this court, whether the court, any court, applies the law regularly, that is a different matter. And there are channels. You appeal. You appeal. That's what he told me. Now, And lastly, Madam Chairman, we pray that
Guys, liking, I'm liking it. I'm taking I'm liking. Thank you, Nathan.
unless the law assisting, but Madam Chairman, lastly, we pray that from my side, because my senior colleague is going to give it a final push. We pray that you really be pleased. Let us on the law, and especially where you are satisfied with the decision to the ruling of court where you are supposed to go. So, and my colleague, my senior colleague is going to bring this home.
Chairman, I associate myself with my young brothers, and I have something to add. In regard to impartiality, when you look at Article 142, appointment of judicial officers, Paragraph 1, the Chief Justice, the Deputy Chief Justice, the Principal Judge, the Justice of Supreme Court, Justice of Appeal, and the Judge of High Court shall be appointed by the President acting on advice of the Judicial Service Commission and with approval of Parliament. Now, our colleague
Nathan, text you on my WhatsApp. I have to add you in Extreme Media Group. Nathan.
You cannot get the thing from this one. The same person who appoints these justices and judges is the same person when you look at the section 194. The same person that appointed the board members, the instrument which you read to the accused person, that is the commander in chief, is the president, and is the same person. So where is impartiality in that regard? So that one does not require any constitutional interpretation. Section 208 was also attacked of the UPDF Act. I want to go you to look at section 4 of the Penal Code.
Subscribe, like, comment and share the link. You're watching Extreme Media Yogi.
Section 4 of the Penal Code Act is about the extent of jurisdiction of courts, and it states the jurisdiction of the courts of Uganda for purposes of this code extends to every place within Uganda. Notwithstanding subsection 1, the courts of Uganda shall have jurisdiction to try offences created under section 23, 24, 25, and 26 committed outside Uganda by Uganda citizens or person ordinarily resident in Uganda. For avoidance of doubt, the offences referred to in subsection committed outside Uganda by Uganda citizens or a person ordinarily a resident in Uganda shall be dealt with as if they had been committed in Uganda. And those, under those sections, those offences are treason and aiding military to police officers, that kind of offences. And now when you go to section 3 of Anti-Terrorism Act, section 3 of Anti-Terrorism Act, the territorial jurisdiction of courts of Uganda in relation to offences under the Act. The courts of Uganda shall have jurisdiction to try any offence prescribed in this Act, whether committed, if the offence is committed in Uganda or outside Uganda. So, it's, the section puts down all circumstances under which the offence can be committed. The offences committed outside Uganda, to which this section applies, shall be dealt with as if committed in Uganda. So, this section is almost the same wording as section 208 of the Human Act, where these officers are asking, where do we get the jurisdiction to try an offense which was committed in Kenya? So it's not the what is special about this. This is it's not the news. What should be interpreted by the Constitution of God.
Nathan, thank you so
So
much.
jurisdiction extends outside Uganda according to the statute. And we earlier stated that jurisdiction is a creature of statute. Therefore, there is no need for such a section to be applied to the Constitution for interpretation. What would you be interpreted? My Lord Chairman and all court members, we do believe that our honorable colleagues are aware. They are citing Kaparazuka case, but they are aware that that case, if you are to implement it, there must be execution. You go and extract the execution order. And if you get that order, we would not, this honorable court would be, it cannot proceed in trying the civilians. If an execution order, and you know how to get execution order. If you don't know, then you need to go and get it. Your message. So it would be frustrating the highest court of the land and women verbatim how they in the result, we allow application and make the following orders: execution of and or giving effect to the orders and declarations issued by the Constitutional Court in the Constitutional Petition number 45 of 2016 between the parties hereto are stayed until disposal of applicants intended appear. Who are you to go against the order of the Supreme Court? Chairman and all both members, that is the position of the law. And even in the case it is not getting, if we go to proceed, personally, I think I could even begin to give a reason that we don't have jurisdiction. Chairman and all both members, until otherwise, as of now, we have jurisdiction. So there is no matter that we qualify again for constitutional.
Thank you so much.
The fact, I take the issue of Chisa error. The issue of Chisa error. First of all, it did not arise from the judging the ruling of this court this morning. This was a different matter. Court never made a ruling in regard to Chisa error. And court determined, pronounced itself, and it is factus officio. So there is no way out this court and again. Time the same point of law to interpret what happened in that way.
Ivan, for the record, and in rejoinder, I'll be brief. The beauty about attending class is that some learn and some do not learn.
Listen.
Council Kalibala, Council Mbanga, Council Kalua, and Council Kwako went into further detail about the constitutional provisions, the questions vis-a-vis the UPDF Act and the Constitution. I am disappointed that they did not get a financial benefit for that, but they offered it free of charge for us all to hear and listen. The actual fact that we sit here and says that does not raise a question, that is a question, is the actual reason as to why we should be in the Constitutional Court on such matters pertinent to this matter. I also want to state, in general rejoinder, that it's not the duty of the prosecution to frame questions that we want the Constitutional Court to address. And nor is it the duty of this Honorable Court, with all due respect, to usurp powers of the Constitutional Court under 137 to interpret questions posed by the parties. I also want to state unequivocally that there are two legs within the Constitutional Court. If it may please you, I will substantiate on the two legs. On the two legs, there is one where the court deems it fit to raise a constitutional question. That is one leg. And in the wording of the Constitution, they use the word may. I believe that you as officers of the UPDF understand command, order, and all that. The second leg of that Constitution, Article 137, 5B, gives latitude to the parties to escape the tyranny of a court, tribunal, or a disciplinary committee by allowing the parties to pose a constitutional question. And we didn't move under the other leg one. We used leg two to protect and defend the rights of the accused person. And that leg in the Constitution, it says shall. It is coiled in mandatory terms. The Supreme Court has been in position to guide in a number of authorities about the coiling of the Constitution and the word shall and may. And the framers of the Constitution, of which Dr. Besigye, one of the accused persons, was, is very clear and instructive. So it's our duty to ask that the professional UPDF under Article 208, the profession and professional soldiers should respect the command and the supremacy of the Constitution, of which we are all here to defend. Members of the General Court Martial, I also want to mention that when the prosecution wants to phrase its own questions,
we shall present them before the Constitutional Court. We have framed ours, and we are saying this matter warrants a constitutional interpretation. Members of the tribunal, I do not understand the obsession with the Kabazura case. My senior has already alluded. I said the General Court Martial, Tribunal, or any disciplinary committee. And with the word court, if it appeases your ears, I shall maintain that. Professionalism means respect to the rule of law. None of you will be hurt, or there is nothing for you to lose if you refer our questions to the Constitutional Court. And in the way, counsel lied to this honorable court by saying that these courtesans are not tied. Actually, they are tied with chain and shackles. And I will address in broader perspective about the MOU you talked about. That MOU is alien to us, and it's not anywhere within our knowledge. All that we are so sure of, Article 79 of the Constitution only gives powers to Parliament to make laws, and also has a condition that no one else can make laws that have force in Uganda. Whoever that MOU might have had his own wishful desires, and that's not our problem. Our problem is that the law of the land must be enforced the way it is to the land. And also, in the most severe, I want court to take judicial notice under the ABS Act, as told by Senior Palibala, that even in the most cases of Jamil Mkulu, there was an extradition from Tanzania. As to whether the accused person did not enjoy that benefit is also another phenomenon we are about to explore. I also want to state that the issue of impartiality has been largely misunderstood by my colleagues. It's not about the members of the court, no. It's about structural issues rooted in the UPDF Act vis-a-vis the Constitution of the Republic of Uganda. We do not have any desire to impute the credibility of the members of the panel, and we have less appetite for that detail. I also want to state that, having said so, these are our questions as to whether they desire to make submissions challenging any of the interpretation. Unfortunately, none is qualified. None of us is qualified or authoritatively to do that, save from the Constitutional Court. And trying to do that is violating and usurping the powers of the Constitutional Court and molesting and defying the Constitution of this Republic. The idea that we court covers Guruka and leave other cases that have been decided and not appealed is appalling, and should be the duty of the officers of the UPDF to maintain the stature or the desire for the UPDF to be a professional army. And finally, when a matter arises, when a constitutional matter arises, it has to be referred for interpretation. Otherwise, again, I say, none of us is qualified to interpret the Constitution. And another rider is failure to respect the interpretation of the Supreme Court, also tantamount to violation, molesting, raping, defiling, and abrogation of the Constitution of the Republic of Uganda. We desire, it's our desire, that we do not want the UPDF and its institutions, most especially the General Court Martial, to trade and train that way. Again, we do not know about that MOU being quoted. We do not know it as under the laws of Uganda. We also do not, we are certain that it did not conform to Article 91 of the Constitution of the Republic of Uganda, and whoever made it can as good as use it to light a fire and a charcoal stove for their own benefit. Thank you so much.
Guys, subscribing, liking, and commenting.
And members of this court, I want also to take this latitude to add on my voice as the defense team of Dr. It is quite very paradoxical and various for prosecution to allege what was shown jurisdiction that this court has interpreted. Whereas we take the evidence of the fact that the Constitution of the Republic of Uganda ushered in this very new court martial to peacefully go to handle cases regarding this criminal benefit. It is not true that because by virtue of that very enabling provision of the Constitution that you have jurisdiction of the administration. I would love to implore this court to adopt this decision. While the Constitutional Court was faced with the same similar matter in the case of Honorable Sam case which we had prior in the morning while submitting the same was submitted by the defense team, that is by the House of Lords in this case, while elucidating on these facts, we are able to persuasively adopt the decision in the Namibian case of State versus Johnson, 1991, volume 20 at page 813, and it was to the effect that the Constitution, this is the catching word, the Constitution of the nation is not simply a statute, which mechanically defines the structures of the government and the relationship of the government and the governor. Those are the few catching words. It is a mirror of reflection. When you go to a mirror and you put in front of you, you can able see what is happening in you. So this is a mirror of reflection, reflecting the national soul of the identification and the ideas and the aspirations of a nation. The articulation of the values bounding its people and disciplining its government. In summary, therefore, as I invite this honorable court to adopt, and they should respectively adopt these decisions. These decisions act as jurisprudence, they are binding precedents. This is a decision from the Constitutional Court. This is what the House of Lords had to say, that in interpreting the Constitution, that's why I'm different from the view of my land friends. They are trying to hoodwink and mislead this honorable court, which we don't disregard. That in interpreting the Constitution, the rule of harmony and completeness requires that the constitutional provisions should not be looked in isolation, but rather the Constitution should be looked as a whole document. That's why it is because of the Constitution is referred to as the ground law. Article 2 clause 2 of the Constitution is very clear. If any law is inconsistent, is repugnant, any regulation, including the one which this General Court Martial is citing, if it is inconsistent, it is contrary to the provisions of Article 2 clause 2. The framers and the promulgation of that very article were alive to the fact that certain issues arising out of doing proceedings like similar might arise. That if any law, if any regulation which is inconsistent with that very particular article, it should be declared null. And it is because of that very same article that we are trying to invoke Article 137 to enable us to refer this matter for reference. So it is misleading and it is quite very paradoxical. I humbly request that this honorable court will please associate the submission of the prosecution. They are miserably failed at any step with any of evidence to prove their case. I so think.
Honorable Chair and honorable members, I am grateful to my son friends on the other side. Because in my view, they have not dealt with any of the issues that we raised. I'm grateful that they have made our work with. We are past the stage in this country where we should have mechanical responses to the issues. Just say no because I can say no. I should say no because it is value the position that I have adopted. I have listened carefully to what my land friends have said. A lot of it sounds to me like the arguments we will invite them to make when we go, hopefully, when we refine the Constitution. Because those arguments will be very important in that way, as it interprets the articles that we have cited. Honorable Chair, we did say in our submissions initially that the questions around impartiality have nothing to do with the 5 members who are in this court. It's not personal. We have no doubt that the gentlemen and lady officers who are in this court are fine gentlemen. But the regulations we cited, they are laws, they are not individuals. I appreciate fully the idea that the High Command and the General Marshal have different roles in street. I read a rule which says that the High Command can consult on matters of law. I haven't heard, I think it's 69, I haven't heard the response that says it can't. If we take it to the other side where we are used to appear, there is no similar provision where a judicial officer, also appointed by the president, can consult. It doesn't sit particularly with the idea of so it's an institutional issue, it's not a personal issue. It has nothing to do with the gentlemen before whom and the ladies before whom. Honorable Chair, honorable members, we treasure the Constitution, as I am sure you do, because it is the only one that equalizes all of us. Only one, where everybody can look and say, I am equal to this one, in that document. So we find comfortable with some of these things that trivialize, especially where they have trouble with the Constitution. This is not a petition that we are asking to be made, this is a reference. There is a reason why we have a difference between petitions and references. And what I honestly expected my land friends to do was to enrich the questions so that we go together and come back together better enriched. knowing where everybody can trade, so that we are not working in eggshell, nobody is working in glass, nobody is. That's what I expect. That they would come and say, the phraseology is not proper. Honorable Chair, this is a better phraseology. Because that appears to us to be what must happen when Article 175 bill is approved. So I would invite the Honorable Court to consider those questions as posed, and perhaps also just put another small matter to rest. The question of how you refer. There has been reference made to rules on petitions and references. That is the stage we will get to when the reference is being made, because there is a formal document. It will be presumptuous of us to raise the questions and then just consider the reference. We would have been hoping that we would have agreed together with that bill, so that we focus on what the court will submit. The questions that we posed were our proposals. We thought they covered the necessary ground. My brothers on the other side, can we reach them? In fact, I invite them to do so. So that when they are leaving the court, we are in agreement about what those questions are. We are not debating at all the power of the appointing authority. The appointing authority appoints many people. But if an ambassador were appointed and is given, allowed to exercise judicial power, we would argue the same things. Although they were appointed by the same. If an RDC attempted to exercise judicial power, are also appointed by, we would argue the same. We are just dealing with matters of law. They affect laws. They are for the benefit of all of us. Today, tomorrow, in the future. So we shouldn't deal with them lightly. They are serious. Lastly, my learned friend Rafael knows that constitutional interpretation is a matter in realm. It's not in persona. It is in realm. Once the court says A, it has said A. Only a superior court can unsay A. We have cited before you a number of authorities where the court which interprets the constitution has consisted. In fact, in one of the cases, they just said we adopt the other views in the master plan. Consistent. There is no other interpretation. We have one, only one. We must abide. If indeed we are subordinate to civilian authority, we must abide until there is another interpretation. So there is no state for Semoju, there is no state for Captain Yarugaba. I'm not sure why. Uganda society that was referred to was confirmed. The position is clear. And I invite you, very respectfully, to appreciate that position. To do the right thing. Send us where we can set these questions. They will benefit us here in this case, they will build in other cases, build it in the future. We will have to. Wow. This is about all of us. Every one of us in this room. Everyone must go home comfortable in the knowledge that we know what the law says. Because again, in this jurisdiction, there is only one person who cannot be subjected to these types of processes. Only the sitting head of state. Everybody else. Everybody else, without exception. I thank you, Honorable Chair. My land friend wants to close.
Thank you, Chair. Briefly, one, the issue of Carol Michiza did not arise in today's proceedings. It's neither here nor there. Chair and members, the constitutional reference is not only about this rule. It's about the proceedings right from the very moment charges were read before them, and also the rulings that were made that you have jurisdiction. It's a whole package. So it's misconstruing the context of this petition, rather request for a reference, all the proceedings we have had. So that's across. The other thing is about the East African Treaty, the MOU. He made some submission here which is really disturbing, that your ruling is settled it all, and it's fine. You are the alpha and omega of interpretation of the Constitution. Is this an appellate court? That is not really the position of the law. We take exception to that, it's outrageous. And it's not also an appeal to the court martial appeal court that this is an attempt to appeal. No. It's very clear, grounded under the constitutional provisions. On the question of the Supreme Court, they said there are decisions of the Supreme Court, the order of state specifically in Kabasukuruka. I want to address you on this. 5th of August 2021. And the decisions we made reference to of Semunju and Amon Biagava, reaffirming the Kabasukuruka position of 2022. So this order is not applicable. And I want us to put it in context, Mr. Chairman. I have a copy here. They are consequential orders that were given. That all files pending before the General Court Martial be transferred to the civil courts. That was the consequential order, which was still not the interpretation. And it's the reason he advanced the argument that the decision of the Constitutional Court is in rem, is not in persona. So the consequential order is the one that was stayed. But the Constitutional Court has been consistent that the interpretation about the jurisdiction has not been overturned. If anything, it has been reinforced by the recent Supreme Court decision in the case of Ogwang versus Uganda. If I may just read one aspect of it, it's very, very important and instructive, Mr. Chairman, so that it's the only Supreme Court decision we have, the only one on this. And no misconstruction should be made to say that the Supreme Court has got any other order as far as the jurisdiction is concerned. As they are getting it for me, allow me also refer you to the submission on the applicability of the Firearms Act. Mr. Chairman and honorable members, the Executive case is very, very clear. It's very, very clear. The General Court Martial's jurisdiction is only limited to trying service offences specified under the UPDF Act, only in respect to persons subject to military law. Offences under the UPDF Act, military law under the UPDF Act must be construed to exclude laws that are the preserve of civil courts. This has not been set aside. This has not been subjected to any other interpretation. So where do they derive that argument that this honorable court is involved with jurisdiction to handle matters under the Firearms Act? So the East African Treaty, I want to talk about the MOU and the East African Treaty. They were again misinterpreting this decision of Omar Awad. Omar Awad, the extract they were making, the extract they made is very clear. They were talking about repatriation of fugitive offenders. And when you look at the Extradition Act, the fugitive offender is defined. A person having committed an offense, you run away from the jurisdiction. And again, in this particular case, you find the case facts, you read the facts. In Tanzania, for example, where these people were repatriated from, there were extradition proceedings, only that they did not wait for their appeal. So, this East African Treaty did not in any way purport to outlaw the Extradition Act, or in any way to repeal it, let me use that word. The treaty did not repeal the Extradition Act. It is still good law, and it must be complied with. So, an MOU made under the treaty, which is also subject to question because we have not seen it, cannot be said to be within the parameters of the extradition law. Now, to emphasize the other point, Mr. Chairman, I want to just read that extract for one. In our view, the body of the UPDF Act specifically sets out the army courts as a parallel judicial framework, distinct and juxtaposed against the courts of judicature. It appears to have been contemplated that the UPDF courts were better placed to address the discipline issues within the rank and file of the armed soldiers, and better able to handle out penal sanctions, that hopefully deter further offending. It is through these structures that UPDF soldiers are made accountable. And they concluded by indicating that the Constitution of the Republic of Uganda, which gives Parliament authority to make such laws, as provided for under the relevant provisions, deemed it necessary to create a disciplinary court. They emphasize a disciplinary court for the members, the rank and file of the UPDF and members of the UPDF. So, this reinforces the position given by the Constitutional Court that the jurisdiction of this honorable court is restricted to those matters which are within the UPDF Act and not any other. That is the latest decision in Ogwang. Now, finally, the issue of of the procedure, Mr. Chairman, this issue of procedure, the procedure to follow here is very, very clear. Once you move court for deliverance, the questions are formed, are raised. They are framed. The questions are framed. So we are at the stage of raising these matters for purposes of framing the questions. And this is important. So I don't know how else they wanted this to be done. And this has been the practice all through, that you raise the questions, you raise issues, and then the questions are framed. So they can't fraud us on the procedure we have adopted. Allow me to invite the Council friend to add one or two submissions. Then we have.
Thank you, Mr. Chairman. Mr. Chairman, I'm going to be quick because it's been a long day.
Subscribe.
My colleague, Colonel Raphael, I hope that's correct, Ram.
Extreme media.
Similar provisions in the Penal Code and the Act regarding terrorism. I just wish to remind him, Mr. Chairman, that none of the offenses in the charge sheet and the amended charges for that matter are brought under the Penal Code or the Act regarding terrorism. So that attempt to juxtapose it cannot really follow it. The other one, he did refer to the appointment of the lady and gentlemen officers of this court and saying that they are also appointed by the Fountain of Honor. It is correct. Just to remind the court that when the judges and justices have been appointed, because they do perform a function of determining rights and obligations, including determining whether someone should leave or not, there is an extended process which starts right from running adverts in the newspapers, whereby the public states. Mr. Chairman, we are not aware of any such similar cases of an advert regarding the membership of the court martial. We are also not aware that the most junior and this officer of the Uganda President Forces perhaps engages in the process that appointed the ladies and gentlemen officers before us. We want to assume that that is at the pleasure of the Fountain of Honor, perhaps in communion with the members of the High Command. And that is why, as my land friend alluded to, that Regulation 69 envisage the good manners that you revert to your appointing officers. The challenge there is, Mr. Chairman, is that it wouldn't be about budgeting or the logistics, as our friend tried to say. It actually says you refer to a point of law. Mr. Chairman, matters regarding life and death are matters of law because the Constitution dictates that one shall only be deprived of life by a decision of a court of law. So my submission is that by removing that function and causing you to make reference to a body which is not here to hear the evidence, to determine, to see the demeanor, to see the veracity of evidence, is to undermine the impartiality. And to that extent, I will add that while my land colleague gracefully and passionately and professionally referred to what he was told by Mr. Kalibana, I am alive to the fact that he did not teach him that one. But it's over time, so perhaps
maybe a slip of mind. Mr. Chairman, the other one was in regard to the MOU. Mr. Lupago, Council has seen we prefer the fact that we have not seen it. It is not, even where we don't have a hard copy, perhaps Council should have been gracious to say it is dated today, it was signed here, and signed by these people. Because the Constitution, Mr. Chairman, in Article 123, reads, the President or a person authorized by the President may make treaties, conventions, agreements, and other arrangements between Uganda and any other country, or between Uganda and any other international organization or body in respect to any matter. The second sub-rule, sub-article is that Parliament shall make laws to govern ratification of treaties, conventions, agreements, and other arrangements made under Clause 1. It means that an agreement, which would be an MOU, which has not been ratified, cannot be or operate as a law, as I call it. It was therefore, my Lord, Mr. Chairman, Section 4 of the Treaty of the Act which deals with ratification of treaties says that all treaties ratified by Cabinet shall be laid before Parliament as soon as possible. So to the extent that the procedure commanded by the Constitution was followed, our colleagues shouldn't have been referring an MOU. They should have been referring to an act which was laid before Parliament, which arose from a ratified MOU. So to the extent that we are looking at an agreement, Mr. Chairman, I don't want to assume that my colleague would agree that as it happened to the accused persons, A2 and A3, that if that fate befell him in the General Court Martial in Kakamega in Nairobi, he would argue that I am here properly because of an MOU I have received. So we request that, again, the right thing is done. We cannot, based on an argument, determine rights and movement of people, as Article 123 commands. Lastly, Mr. Chairman, is the prosecution team, heavily led by Colonel Raphael, did, in their view, read the questions to propose and the provisions of the law, and in their view found that there was nothing to that. Mr. Chairman, the point we are making is that the interpretation we are seeking is not the meaning of the words in the statute. That's not the interpretation. Under Article 137, 5b. The spirit of that article is that it envisages a state of affairs such as now, which could be an act as action of the law, but which must be put into perspective or juxtaposed with the supreme law, which is the Constitution, to see if it complies with the basic requirements of the Constitution. So it is correct that when we read those sections, we understand what they say. We are only saying that to the extent that we understand them the same way as they do, those brought so or should be brought within the perspective of the Constitution to determine whether they will contravene the rights of the accused persons. It's not the ordinary meaning. So we do request, and I have seen, Mr. Chairman, that our colleagues do not quite disagree with the way those questions are framed. my colleagues have said, that's what was expected, that's what the law envisages. As my colleague read the rules, that once the questions have been raised, the role of the court is to frame those issues and forward them in the manner provided by the annexure, 8 copies. To the extent that they don't disagree with the issues as framed, I request that the necessary result should follow, that the questions as framed, which they appreciate, be forwarded to the higher court interpretation, just so that when we come here, we don't bog this court down with objections, because then everything shall be in the clear perspective. We thank you for listening to us.
Guys, subscribe, like, comment, and share the link. You are watching Extreme Media UK. Subscribe, you are over 400. Why don't you like the video? Listen carefully. Subscribing, and you like the video. Manange bibasuse enkola babe kuba amaaso. Look, be careful bw'obwama. Subscribing, liking, and commenting. You share the link, share. That's how I would know. Anytime from now. The court have been adjourned for 1 hour.
To rule on all issues related to
Guys, the court have been adjourned for 1 hour. Guys, the court have been adjourned for 1 hour. Guys, send me some money. We are watching Extreme Media UK. The court have been adjourned for 1 hour. I feel there is progress. Sawa zili 10 nenda shika 19 ndio the court have been adjourned for 1 hour. Subscribing, liking, and commenting, and you are watching Extreme Media UK. Jogeza Nicholas Kete, video Nicholas is my name. Guys, alinayo ka data kati site kubanga tukyali wano nayenda basina data wano. Data alinga ngene obuzi bwako. So subscribing, liking, and commenting, choli no manya. The court badyongezaayo, it has been adjourned for 1 hour. Alright. Lero luno. Olwalero luno. Chika chitokota. Tuli. Bwemana ekebeddekebedde ekintu ekimukumbulamu kiri kimu ensonga ya data. Ensonga ya data naye nga you are watching Extreme Media UK. Amazimako ekoti bagyongezaayo, it has been adjourned for 1 hour. For 1 hour. Sawa zili 10 nedakika 2 11 tukomerawo. Guys, the court have been adjourned for 1 hour. Labayo kusongaganamu oluka wano. Labayo. BC. Subscribe, commenting. Akunda kufa gano tugawala bidama no Extreme Media abati byo banaga kwa sawa muka tumanyi wa subscribe atera commenting
ekintu kiwandiikidde naye watemyemu tulizo abanze
naso sene mpozi nanzija Tokyo Junior, hope you're watching. And now, I'm tuli wano. Mukategedde akantu ako. It has been adjourned for 1 hour. So all you need to do is subscribe, like, comment, and share. Abanange nange kantuleko. Oyafande nokubanga naye ekyuma kyembagambe. I used to gym with that afande. That one on the guard. I used to gym with him. So guys, send me some money. Yeah? You get the point? whenever you're watching us from, where are you watching it from? 1 hour or 10 years in jail. I think there is progress. Kirabika bayinza okumuta, bayinza okubata. Tulaba okwange mulabo kangayizi mutu twetaagayo kadata wali eri wonna tusooka tulabe nga tukwasaganya ekintu kino magezi mpola. You do it abaagaliza Dr. Kizza Besigye emirembe, abamwagaliza ebirungi, abaana ba struggle, abaana mostly abali diaspora, mutuyambe muko wano, mutukwatemu wano eno, tulabe ekitunga tukitambuza mu magezi mpola. You are watching Extreme Media. Yugi Jogeza Nicholas aka John Paul Yugi is my name. Subscribing, liking, atera commenting. Enamba ya MTN genda ku profile yangawo ya YouTube olabeko namba ya MTN, otekawo otyotekako neba miliyoni namba tuzitwala, neba miliyoni namba esobola okuba nga etuyamba nitubeera nga tukola ekintu kino magezi mpola. Subscribing, liking, just pin the message. Samuel Trash bro, anti katolaba obuzibu kanteke wano eno akategedde akantu ako sina